and good to have you with us at the 9 p.m. edition of the Urban Debate. We have two big conversation points tonight. First up, we start off with a subject that we have debated many times in the past. A subject that we've debated with politicians, with legal experts, and even representatives from the police force. It is important, it continues to be, in fact, it probably becomes more and more important with each passing day because of the use of this law. And I am talking about the Sedition Law and the way it is getting used by our governments, state governments and center police forces in many parts of our country, and why I feel it's a concern. But first, let me tell you why we are talking about it again tonight. Because the Supreme Court was hearing a case, a plea filed by two news channels from Andhra Pradesh. And they filed a writ petition challenging the action by the Andhra Police to book them under the Sedition Law. These channels were booked for airing alleged offensive speeches of a rebel YSRCP MP. They aired the speeches of this MP, which is why allegedly they were booked for sedition. And the channels went to the Supreme Court seeking relief. Supreme Court has restrained the police from any action right now against the news channels, from any arrest or prosecution. They've issued a notice to the Andhra Pradesh government as well. That's not the case I want to talk about. It's never really about individual cases, but a larger trend, a mindset that governments may have, which could become problematic. So then let me tell you what the Supreme Court observed during this hearing and what it intends to now look at. The Supreme Court said FIRs are an attempt to muzzle media freedom. It is time that we define the limits of sedition. Supreme Court today said this. It is time that we look at defining the limits of sedition. We need to define the scope of offences under sedition and promotion of communal hatred. The provisions of 124A and 153 of the IPC require interpretation on the issue of rights of press and free speech. The FIRs do not establish offence invoked against the two news channels in this case, and so no coercive action should be taken until the hearing. Here is the topmost court of our country saying it out loud and clear that perhaps it is time to define the scope of this law so that it isn't misused against the people of our country, so that it isn't misused to silence the dissent, to muzzle the free speech, and to target the media. So let's once more talk about the sedition law, the increasing use of sedition law. Where did it really come from? For what purposes can it be used? And where should it not be used? Miran Borwankar, former Commissioner of Police for Pune, joins me this evening. Yashovardhan Azad, former IPS officer, with me this evening as well. Gunjan Singh, advocate with the Supreme Court, joins us this evening. And Mr. Vikas Singh, former ASG, joining us as well. Mr. Singh, I want to start off with you. We've had several examples just in the last 1 year, from the central government to individual states who've invoked the sedition law against protesters, against artists, against the media. Do you believe it is perhaps time to define it further to say what really accounts for sedition?
Well, according to me, the Supreme Court has done that job a long time back in the early 50s in KK Singh's case. And in spite of that definition, that is clarity given by the Supreme Court, unfortunately, the states are not, understanding. And that is why in the case of Vinod Dua, because a sedition case had been slapped on him by the Himachal Police, and I have filed a petition in the Supreme Court where judgment has been reserved. And one of the prayer in my writ petition is that before you start any criminal case, not sedition, any criminal case against a journalist of a certain standing. I have said standing because everybody can claim to be a journalist. I don't want, this protection to be misused by people saying that I'm a journalist. So a person may be 5 years standing or 10 years standing, that there cannot be any criminal case registered against them without the reference to a committee, independent committee, and the committee examining whether a criminal case is made out or not. Now, a similar law of this nature is already there for the medical professional. There is a judgment of the Supreme Court which says that an FIR cannot be registered against a doctor without referring it to a medical board. So similar requirement should be there, or the better way option would be to scrap this law altogether, because it was framed in 1870. It was framed by the Britishers at the time of independence. Probably we should have done away with it, because when we gained independence, this law, according to me, was not required. But if we have not, done away with it then, definitely the time has come to do away with it now, and that there should be an amendment, or there should be a quashing of this section from the IPC altogether, because this is more being misused than being used, unfortunately. If that exception can be carved out for the media persons, probably this law can stand. Otherwise, I don't think it will stand the test of judicial scrutiny.
Okay, very interesting that you say that. So let me actually bring in Miran Bhovankar as well. Ms. Bhovankar, do you believe that in the 2021 of India, there is no place for a law that was created during the British era for a specific purpose?
Yeah, I definitely feel that there is no place for 124A of Indian Penal Code. That's the sedition law. But I feel that the particular section we refer to, that should be removed altogether from the IPC. And I don't feel that this protection should be available only to the journalists. I feel it should also be available to anyone who has a particular grievance against the government, has the courage to talk about it, write about it, but has no intention of inciting any kind of violence. So this protection should be available to all in the country. This particular section should be scrapped. And in fact, youth, which is so vocal on social media, and the media itself, which is highlighting COVID catastrophe, should be encouraged to bring out the truth. By slapping this act, you are trying to silence them, when in fact what you need is the truth. Therefore, my very strong opinion, encourage dissent, let people speak out. Don't try to silence them, silence opposition, silence youth, or silence media. Scrap this section.
Well, let me actually, for the benefit of our viewers, just also read out what this section 124A, which is the sedition law, really says. Whoever by words, either spoken or written, or by signs, or by visual representation, or otherwise brings or attempts to bring hatred or contempt, or excites or attempts to excite disaffection towards the government, shall be punished with imprisonment for life, to which fine may be added. So dissatisfaction towards the government includes disloyalty, all feelings of enmity, essentially, which is why, Mr. Yashovardhan Azad, so often we see when somebody is criticizing the government, in this case, it probably started off with a rebel MP from the same party. It not just landed him in trouble, it landed 2 news channels in trouble. The last big controversial case was that of Disha Ravi, who perhaps was looking at spreading a campaign on social media and ended up being in jail for sedition. What's your view on this law?
Well, I'm surprised at the spike in the cases of, sedition. And, in 2019, there were 96 arrests. It's shocking. And there were 3 convicted. In fact, the rate of conviction is around 3%. And despite the court saying again and again about sedition very clearly that, any criticism of the government does not mean sedition. I mean, unless it does not incite violence and there is no imminent violence or anything. why this is being kept. So in that respect, you have complete unanimity. In the case of Andhra, it looks to me it's a pure political fight. I mean, Raju is a gentleman who has changed sides a couple of times. He has raised the issue of cancellation of bail against the chief minister for the cases which have been registered against the CM for corruption, etc. He has talked against, the COVID management which is there. And it is very interesting, Tanvi, let me tell you, that 100 years back in 1916, Bal Gangadhar Tilak, one of our greatest freedom fighters, had given a speech in Belgaum and Ahmedabad where he had accused the white servants of the British Raj of behaving as if exactly like the company, East India Company, as rent seekers, and that is why he wanted home rule. And you know what happened? The government first saw the case, and the law officers said that it does not amount to sedition. So what we should do is that we should 108, that is, get security for him from good behavior. He did not, Bal Gangadhar Tilak did not even offer security to the district magistrate, so the matter went to High Court, and he was discharged. So today I am shocked that while criticism during that time was, the case was discharged against him, how this is being done by the state government. It's a shocking thing. And I think, sedition in Hindi has a greater impact. It means Rajdroh. And is this Rajdroh a criticism against the government? I am fully agree with Miran that it should be kicked out and it should be thrown out. It has no place.
Gunjan Singh, let me ask you this question, not just from the point of view of the relevance of it, but just how hard it is to prove a case is also reflective in the conviction rate that we see when it comes to sedition cases. I mean, half of those really don't even make it to a proper trial because the charges are so frivolous and usually invoked by the police or the states to just target people or harass them and silence them. Isn't that a reflection as well of how widely it is being misused?
See, I'm in full agreement with other panelists, and as everybody agreed that this law has to be done away with. And as you rightly said, that the purpose is never to convict anyone and to bring the trial to an end, but it is always to harass people, student activists, young activists, all across the country we witness. And unfortunately, there are lesser known incidents. There are 30,000 people slapped with sedition charges in Jharkhand. In 2018, there was a movement called Pathalgadi movement. We know of selected cases from Bangalore, Delhi, here and there, but we don't notice that. 30,000 people from many villages were charged with sedition. Though government has not started prosecution of these people yet, but just look at the scale of the colonial relic which is being used against innocent villagers and poor people in this country and tribal people. And we have seen how students in JNU, how Manipur journalist Kishore Chandra has been harassed and many other journalists. And I have a slightly different view with my senior colleague here who said that, journalists of some repute. But I would say that this law has to go because it is not only senior journalists. Even a student, like in Karnataka, a child was slapped with a sedition charge. So we have many incidents where people right across the country who speak against the government are being charged with sedition.
No, you're absolutely right. And I just want to say this as well, that I agree with what you and Ms. Bhavankar said. I don't think it should be for a specific profession of people at all, whether they are doctors or journalists or anybody else. The law as it exists or should exist should apply to everybody. Everybody, Mr. Vikas Singh, has a right to speak up, speak their mind, criticize the government. So let me ask you this, because two of our panelists have pointed out, do you also believe that it needs to be totally done away with, or as the Supreme Court says, perhaps redefine the scope of the law?
Well, when I said that there should be a committee for registering a criminal case, this was not in the context of sedition. Right. It was in the context of any criminal case, because there are cases being registered under 153 and various other sections of the IPC against journalists particularly. So that point was not with regard to a sedition law. Sedition law, I prefaced it by saying that the time has come to do away with sedition law, because today, And there is something very interesting I want to point you out in our constitution. Unlike the U.S. Constitution, the Bill of Amendments, the First Amendment and the Fourth Amendment, where they gave this protection to journalists, this right to free speech. In our constitution, there is no word of journalist mentioned. In our constitution, every citizen has a right of free speech. So when I talk of free speech and when I say that every citizen has got it, journalists in our system don't enjoy any special rights at all. Journalists, I have said, only for the purpose of a profession, because ultimately journalists do a very important job of informing the people. I may be, in my very limited knowledge as a citizen of this country, not having the access to the kind of facts which are available in the public domain. And of course, now things with this advent of internet, things are changing very fast. But the journalist is in a position to regularly access information and disseminate information and inform to the public. Now, as long as the profession of journalism stays, I have said that for any criminal case, like the protection has been granted to doctors, it should be there. But as far as sedition is concerned, the sedition law, because the Supreme Court in 1915 KK Singh's case very clearly said that sedition can only be, somebody can be charged with sedition only if the person is accused of inciting violence and resulting in violence. Now, none of these ingredients are made out. And I'll tell you, Tanvi, the bigger problem in our country is of police reforms. And we have the police which is completely sold out to the politicians of the day. And that is why they register all these false cases against the journalists just to please their political masters. If there had been police reforms as suggested by the Supreme Court in the Prakash Singh matter, today these kind of false cases or frivolous cases, either against journalists or even against innocent people who tweet or who use the social media to bring out criticism of the government, would never have faced such criminal cases. So the police is being used by the politician of the day or the ruling party of the day to terrorize the people of this country, to quell dissent. And that is what is the most disturbing part in our country. And unless we have police reforms, this law without police reforms cannot stand. It has to go. If there were police reforms, probably this law could stand with the judgment of the Supreme Court in the 1950s with that clarity that sedition is to be used in a very limited type of cases. So that's the larger debate. I'm not saying that an individual does not have a right to free speech. I'm not saying at all, because our constitution gives the right to every individual. So your right to tweet, your right to use the social media completely protects you from being harassed by the police. But that's the problem in our country.
Okay, so let me then take it to the next conversation point, and Ms. Bravankar, this change. Like Mr. Vikas Singh was pointing out, a lot of these actions, most of them and these cases are booked because there is political pressure, because somebody powerful and influential got offended, somebody's vanity was insulted, and they want a sedition case filed against whoever did that. Now, if that is the case, it's very difficult to expect the government of the day or the parliament of the day to bring in a law that doesn't help them anymore, or repeal a law that doesn't help them at all. So should the Supreme Court take this onus of doing away with the law itself, or should we leave it to the parliament?
Either way, I think Supreme Court has already decided to review this particular section of Indian Penal Code, which I would like to highlight was enacted in India in 1860, but the British who enacted the law and the sedition part of it, they have themselves withdrawn it. In 2009-10, the British have done away with this particular section of sedition. So in our case, it can be withdrawn either by the Supreme Court can declare this particular section of IPC null and void, or the parliament. Either way it can be done, but let's not blame the police officers for registering, because as per my information, except in the Lalita Kumari judgment where we have some window to inquire before registering a case. If a citizen approaches a police station, the police does not have any powers to refuse that, though in practice many times they do. And before you took up this debate, you were showing the other one where the CM of Bengal has exhorted officers from IAS and IPS to come out and battle. She even cited Tagore's where the mind is without fear. Now, let me tell you, even inciting IAS and IPS officers to come out and battle, would you register a case? So my point is that this particular section should be declared null and void. Otherwise, don't expect police to apply its mind at the registration stage. We register, we investigate, we can always close it saying no case made up, which many times we do, or we say it's a false complaint. But registration is mandatory. And at that stage, SHO just takes the complaint and register. And as we have seen, it has only 3% conviction. So we are wasting the national resources, energy, and also earning the ill will of our youth, of our media, of people who are courageous enough to differ with the government.
You're absolutely right there. In fact, let me just also highlight how exaggerated it has become in the last few years. Between 2016 and 2019, the number of cases filed against Section 124A, which is the Sedition Law, increased by 160%, while the rate of conviction actually dropped 3%. So 160% jump in the number of cases, Gunjan Singh, that were filed. And I just want to also highlight here, it's not to talk about one government. I think we have enough examples from state after state, from Andhra Pradesh to Telangana to Karnataka. Of course, the big central ones are extremely famous. But any government that sees some amount of questioning and criticism and dissent seems to be resorting to this now in our country.
See, it was very rightly put in the Supreme Court by former Attorney General, none less than the former Attorney General Mukul Rohatgi, who argued for Mr. Raju, the Member of Parliament here, that government these days deliberately put this section to make the crime graver. And that sums up the whole debate. That is the actually idea behind putting section of 124A. They all know that people who are being charged with this section will walk away free. But in order to intimidate them, in order to put chilling effect on the news channels, on journalists, to terrorize people, to terrorize students, to terrorize activists, that is the idea. That even if you are not successful in making convictions, people will live in a reign of terror, of fear. And that is how the governments are imposing section 124 all across, right, left and center.
So, Mr. Azad, I come back to the same question then. Who does it? Should we expect the Supreme Court to do away with the law? Because as the legal experts here and the law enforcement experts here on the panel seem to be suggesting, a lot of the use and misuse of the law actually comes from the politicians.
Well, I don't think the Supreme Court would, of course, it will define the limits, as it has already said, that it will talk about sedition cases with respect to the freedom of the press. But ultimately, it is for the Parliament to legislate and Parliament to do anything about it. But I have a feeling that nothing much will be done about it. And my second point is that the policemen, of course, can do much better. Filing cases of sedition is an absolute wrong thing, even as per law. It just doesn't apply in at least 95% of the cases where it's being done. So are we going to look at police reforms to do it, as the second question you asked? I don't think police reforms is possible in this country, because in a country where your grassroots politics is being run by police thanas and tehsils and the basic offices, where the elected representatives try to get a special dispensation for themselves to become the Raja Sahab to dispense justice, it is very, very difficult. So the only thing, what do we expect? Look at CBI, for example. The CBI chief has the tenure fixation, has the autonomy, and yet we are having CBI being called a caged pirate. So ultimately, either you have leaders in the police who are coming up, who will refuse this kind of things to be done, or we wait for the public to make it an issue for the elections. To be practical, I see it will take a while. But sedition, about which even Law Commission had questioned, I think there is a reason for it to go. And I don't think it will be difficult to get a majority opinion on this to remove this section altogether.
Why do you say so? All political parties would like to have this option when they are in power.
Not really, because it is not giving them much by way of votes, because ultimately the entire Rajniti country is guided by votes, and it is basically subsidy management. So in the case of, in the name of poor, everything goes. So this perhaps is on the fringes. It really doesn't matter. So maybe if all the parties get together, it can be, but they don't have time for such things. That's a different.
So let's remind our politicians and of course everybody else who's watching this that in 2018 Law Commission looked into this issue and submitted a report. That's what Mr. Yashovardhan Azad was referring to. The Law Commission observed while it is essential to protect national integrity, it should not be misused as a tool to curb free speech. Dissent and criticism are essential ingredients of a robust public debate on policy issues as part of vibrant democracy. Therefore, every restriction on free speech and expression must be carefully scrutinized to avoid unwanted restrictions. On that note, I'm going to thank all four of you panelists for joining us. The topmost voices, the biggest experts on all things legal, on law enforcement. They're telling you that the law as it stands in its current form should not be acceptable to us. That is being greatly misused and abused by those in power simply to muzzle free speech and silence the dissent. And in fact, you're doing a disservice by using it to the extent that you are. When you do file a case of sedition against somebody like Disha Ravi, you do end up alienating a large percentage of that kind of young population, which is simply an environment activist. When you file cases of sedition against politicians and journalists in state after state after state, simply because you're not happy with their coverage, then it is a problem. And which is why the Supreme Court, none other than the Supreme Court today, had to say that we cannot allow this to continue. It is time that we define the scope and set the limits on the sedition law. We wait and watch what happens in this case next. Thank you so much for joining me.